And good morning, Trinidad and Tobago, and welcome to another episode of Strictly Legal, hosted by, of course, yours truly, Rondell Donawa. That's my name. And you are watching WESN Content Capital. Of course, you can stream on www.wesncc.com, or you can watch on all major networks. Now, today we have an interesting conversation for you guys out there. And many people often dislike that conversation when it deals with preparing a will. They often think that it is a matter of death, or they are afraid that maybe some family member wants to take their property. But that's not the case. It's not the case at all. Particularly, at least in my practice, with the advent of COVID, you found a lot of persons decided that, you know what, they're going to take their life and their estate seriously, and they would have started preparing wills. Now, wills is not a death sentence. It is not something to fear, but it's something that you have to do in order to fix your business, particularly when you have many family members, or maybe you have outside family members. So it's important, right, to ensure that you prepare your business and fix it first. And with me in studio today is a colleague of mine, Miss Marissa Bubb, attorney at law. She has a wealth of experience in private practice, and she will be joining me in the discussion, speaking about wills and probate, and also the preparation, everything that you want to know or that you need to know about wills. So when we get back from this break, we will meet Ms. Bubb and we will discuss more. Stay tuned. And welcome back to Strictly Legal on WESN Content Capital. So before the break, I was speaking about the importance of preparing a will. And with me is my in-studio guest, Ms. Marissa Bubb, attorney at law. Good morning, Marissa.
Good morning, Rondell.
And how are you?
Having me. I'm quite well this morning.
Good to see you here, and thanks for joining us at Strictly Legal.
Thank you for having me.
So we're speaking about wills.
Yes.
And of course, you know, as an attorney, a lot of persons are often afraid to prepare a will.
Well, I think that's because people don't like to contemplate their death.
Yes.
Particularly men, I found in my practice, seem to think that they will live forever, or on the contrary, they think, I'm going to die sometime. Whatever happens after I die is whoever survives me's business. So they don't really, there's a reluctance generally to do a will.
And now tell the public, what is a will? Because a lot of them think that a will can be easily made.
A will is a physical document in which the intentions of the person making the will are outlined. Those intentions obviously only take effect or are to have effect after the death of the individual. So that, in essence, is what a will is about.
Right. And what is the criteria for making a will?
Well, it's very simple, despite the hesitation that people feel or the reluctance that people feel. A will, as I said, is a physical document. There are certain characteristics of a will for validity, for legal purposes. So under Section 42 of the Wills and Probate Act, a will must be written, obviously. It must be signed at the foot of the will by the testator. And what do we mean by the foot of the will? At the bottom of the will, the testator, which is the person making the will,
Yes.
must affix their signature. And in addition, it must be witnessed by two adults who are able to attest that that is the signature of the person that made the will.
And these two adults, as we know, they are persons who are not beneficiaries of the said will, those
Correct.
two witnesses.
Correct.
And many persons may ask, can I prepare my own will?
One can prepare their own will. It's not advisable, especially if you are not aware of all the items that you would wish to include or all the specific legal requirements for the validity of a will, but there's no difficulty if you have had prior experience with the preparation of a will, or you saw your mother, your grandmother, or somebody do it. as I said, once you sign at the bottom of the will, you outline specifically all your intentions, and you have 2 witnesses present who attest that that is your signature by signing after, then there's no difficulty.
And you must nominate an executor.
Yes, so that is another feature of a will. You are required to nominate the individual that you want to handle your affairs upon your death, so that that person is known as your executor if male, and your executrix obviously if female. You can have up to 4, the law provides that you can have up to 4 persons acting together jointly as your executor. You can nominate 4 people specifically outlined in your will.
Now, a lot of persons, that point is a good point, because sometimes you find that persons nominate 2 persons to execute their will jointly.
Yes.
Versus where you can nominate someone, and in event that the first executor passes, then the alternative executor, executrix takes over.
Right.
Yeah.
So as I said, you can nominate up to 4 persons to work jointly, or you can nominate persons in what I describe as in the alternative. So you nominate one individual as your executor or executrix, and in the event that person predeceases you or is at the time of your death otherwise unable to act because they have some mental impairment, physical impairment, they're ill, or they are out of the jurisdiction and unable to act, for example, then in the alternative, you've nominated another person. I usually recommend that persons nominate someone in the alternative to the originally intended executor or executrix.
Because then you see a lot of times that if you nominate persons jointly, then when it's time to administer the estate, there are always some sort of issues.
Well, if you do nominate persons to act jointly, and an executor, a named executor, decides that they have some difficulty working with the other party, or, as I said, they are otherwise unavailable to act as your executor, as a joint executor, they can always renounce their right to the probate. So they don't actually have to apply. But what is important for the purpose of actually having your will probated is that there has to be a nominated executor, and that person has to be able to act. So even if the testator or testatrix nominated 4 persons, and at the time of your death, because of course we never know when we will die, we don't like to contemplate it because we just don't know, it's uncertain. Yeah. If at the time of your death, 3 of the 4 executors you nominated are deceased or have moved away out of the jurisdiction, certainly a document, a form is sent to them, and they renounce their right to probate, so that only one person is actually required to submit the document for probate. And
that is where attorneys will come in?
Certainly. One of the things that you have to know about a will is that it has to be submitted to the probate registry for a grant of probate to be issued. So in order for that person to have the legal right to treat with the assets, property, or whatever other dispositions you have made via your will, the will has to be submitted for probate at the High Court Probate Registry.
Probate Registry. And some persons may ask, okay, what can I put in a will? Can I leave my dog to the church, or can I bequeath monies to a trust fund? What sort of asset base persons can leave for their beneficiaries?
Well, Rondell, that's a very interesting question. Although the primary function of a will is to dispose of or deal with your assets, your property, real or personal property as the case may be, real property being land, house land, yes, immovable property, and personal property being movable property. Yeah. There are other things, there are other functions of a will, other characteristics of a will. You can, as I said, appoint executors, you can appoint trustees, you can appoint guardians for your children, your minor children, in the event you die leaving minor children. You can set up a trust, you can make other dispositions in respect of, as I said, personal property. So most people think, I don't have any land, I don't have any property to leave to my children, or I don't have children even to deal with. So why do the will? So there are different things that can be done with a will, and people need to realize that the effect of the will only happens after
death.
Your death.
Yes. And that boils down as well. If you don't leave a will or if you die intestate, then the law of succession applies.
Yes. So if you die without a will, fear not, all is not lost. It just means that a different type of application has to be made at the probate registry. That is an application for letters of administration.
Yes. Now, many persons will come to my office and state that while they are leaving their property, let's say to their children, they prefer that the property stays within the bloodline.
Yes.
And is that something that the law requires, that you cannot sell a property once you bequeath it to a beneficiary?
Well, if you set up a trust, then certainly you can make certain provisions for that property to stay or to be held by the trust and, in effect, to stay within your bloodline. But the thing about transfer of property or bequeathing property to an individual, after you die, that person takes title to that property, absolutely. And just as you would during your lifetime, be able to dispose of your property by way of inter vivos disposition, that is, while you're living. I'm using the Latin term. Yes. Obviously, when you leave property to an individual, absolutely, they are able to treat with that property as you would, to sell it, to gift it, to mortgage it, as the case may be, because there are different things they wish to do with the property.
And therefore, I mean, it's always advised that you have to tell your clients or advise your clients that they can't just, without setting up a trust, that they can't just decide or state that the property must be left or the property must not be sold, because once it's transferred absolutely to the beneficiary can do what they want.
Yes, absolutely. So the old people used to say that they're leaving this property and it's for their children and their grandchildren and their great-grandchildren. Essentially, they think that they are creating that legacy or that trust simply by stating it in the will. But as I have said, unless you actually take the steps to set up a trust, whatever is passed to an individual, absolutely by way of your will, the individual, once they acquire title, that is by deed of assent, is free to do whatever they wish with the property. There's no limitation to what they can do by way of disposition of the property.
And when you say setting up a trust, what is the procedure in Trinidad to set up a trust?
Well, for that, you will specifically need to visit an attorney, because that's not something that the average layman would be able to do. It is a legal instrument that has to be set up. There's certain statutory requirements for the setting up of a trust fund, or a trust, sorry. So that I would recommend and advise that you visit an attorney to set up any trust that you're interested in to secure a particular asset, to leave that legacy. And
what can't you leave to a beneficiary? What example of assets that you cannot bequeath?
Well, as I said, you can dispose of or make provision for any asset that you deem to be valuable. So it may not appear to be valuable to me, but it might have value to you. Obviously, real property, house, land, money in bank accounts, benefits of life insurance policies, jewelry, works of art, motor vehicles, your boat, if you're so fortunate to own a boat.
Your pets?
Your pets, you can make provision, just as some people treat their pets as their children.
Yes.
So that they have set up specific trusts. I have heard of examples of persons setting up trusts for the maintenance and care of their pets upon their death, or after their death, sorry. Anything that is of value to you that you consider to be an asset, you can leave to an individual. Your clothes, your furniture, your antique painting or antique piece of furniture, anything that is of value to you, you can bequeath.
And why do you think that a lot of persons prefer to make a will or prepare a will themselves rather than going to an attorney?
Well, I think people don't, as I said, like to contemplate death.
Or understand.
And they don't understand that even after death, if you have assets or you have anything, for instance, let me go back to the question before. Sometimes at 25, 30, you may not have acquired significant assets in your opinion, but you are aware that there's property that you may come into later on. Your aunt, your grandparents, somebody may leave you property. So a will in and of itself, by virtue of what is called a residuary clause, would cover assets that at the time of the making of your will were not in your possession. You didn't have title or ownership of it at the time. More likely than not, it's real property. But at some point between the date of the making of your will and the date of your death, you come into other assets. This is one of the main things about a will that the layman writing it at home does not appreciate. Yeah. That there has to be what is called a residuary clause to treat with any assets which at the time of your death, at the time of the making of the will, sorry, you didn't contemplate that you owned, you forgot about, or you appreciated that you didn't own at the time, but you would come into ownership of at a later stage.
And that you will dispose of that or that a beneficiary, I mean, you have to appoint a beneficiary for your residual estate.
Yes. If you don't appoint a beneficiary, then that area, the executor has to treat with it, and there are other persons, by virtue of the same intestacy rules, that would be entitled to benefit from it.
Now, I'm sure you will have come across where persons often misunderstand the difference between wills and power of attorneys.
Yes.
Right? Now, now briefly explain what is a power of attorney versus a will. I mean, we know what is a will, but what is a power of attorney?
A power of attorney is a legal instrument by which you, during your lifetime, and while you have mental capacity, give another individual, also called an attorney, not to be confused with an attorney at law, you give that other individual the authority to act for you. It can be a limited power of attorney in that you can specify that this individual is empowered by virtue of this legal instrument that is registered to sign documents, to make deposits into your bank account, to sell your land, to do a number of things. You could specifically limit them to do any number of things, or you can do a general power of attorney. So whereas a will takes effect upon your death, a power of attorney only treats with during your lifetime and whilst you have mental capacity. Why is that so? Yeah. Because a power of attorney ceases to have validity if you lose mental capacity or upon your death, because one of the important features of a power of attorney is that the person, the donee of the power, or the donor of the power, sorry, must be able to ratify whatever act is done by the attorney, the donee.
Yes.
So what does that mean? If I leave the jurisdiction and I wish to leave my mother or my sibling or somebody that I trust to treat with my affairs, I will give them a power of attorney. However, when I return, I must be able to say, yes, this was a valid act by the individual. They did not act outside of the scope of their power of attorney. Yeah. And that is what is meant by ratification. So quite obviously, if you lose mental capacity, or you die, the power of attorney lapses because you no longer have the capacity to ratify.
And one of the main things, I mean, particularly with a will, is that the maker of the will, or testator, testatrix, must be of sound mind.
Yes.
That is equally important. They must be of sound mind.
Yes. So that's one of the important aspects of the attesting witness. The attesting witness must be able to say that they observed the individual sign freely, and it appeared to them, they being two of them, that the person was of sound mind and read over their will and affixed their signature. They were not forced or coerced or otherwise threatened to sign their will.
Now, a signature can also be a thumbprint.
Yes,
because
you
there are
can.
instances
There are
where
instances where persons are illiterate or otherwise physically unable to sign their will. I've done a will, I've done more than one actually,
Yes.
for individuals who are in hospital. Usually when you've had some major health challenge and you find yourself at that point forced to contemplate your death, you call in an attorney to do your will. But you may find that you're so weak that you're unable to hold a pen. But that doesn't mean that you do not have the mental capacity. You are of sound mind because you're able to express your intentions and to communicate your instructions about what you want done with your assets, but you're unable physically to hold a pen. It can be done by thumbprint.
a thumbprint. Marissa, you won't believe there's so much to discuss with respect to wills. And we haven't even touched probate, but time is up.
Oh, that's
Time
very quickly.
Time is up. And Trinidad and Tobago, I mean, I know you have a lot of questions about wills, about the preparation, about probate, but I'm sure with good graces, Marissa will be back, right, to discuss further. You have been watching Strictly Legal. Thank you very much, Marissa, for attending and giving of your advice. Well, not advice, but information to the public. Marissa is an attorney at law based in San Fernando, Gordon Street. And next week, we'll be back with more interesting discussions. I hope you enjoyed today, and I hope you got the much needed information that you require. Thank you, and have a good day.